Everyone, Rilus Dana here for Rilus Law Live. Today we have an estate planning workshop. Let me go ahead and share my screen and let's get started. Okay, so I practice law in Arizona and California. We're going to do a quick introduction. Then we're going to go through some key estate planning terms. And then I have some fun sample scenarios we're going to go through to highlight some different estate planning topics. And then we'll have time for Q&A at the end. So if you're watching online or here in person, we'll save some time for questions at the end. During it, I'll ask a lot of questions, try to keep it fast and fun, but we'll try to keep the answers topical or related, and then I can come back at the end for more questions. So like I said, I'm an attorney. I practice in Arizona and California. I'm the founder of Dana & Associates, practicing as Rilus Law. All right, vocab terms. So in order to talk about estate planning, we've got to know what is an estate. So there's different definitions and different contexts out there. Sometimes people think of just a big house when they think of estate. So in this context, what we mean is everything a person owns, whether alive or dead. This is my friend, Mr. Estate, star of the videos. So an estate is everything a person owns, whether alive or dead. So estate planning is planning for this stuff. So what is a last will and testament? A last will and testament is the document that controls a person's estate. So the person that makes a last will and testament is called a testator. The last will and testament says who the beneficiaries of the estate will be. If there's minor kids, that's where you would name the guardians. And it's also where, you name the personal representative. Now to activate the will, we need Uncle Sam here. This means we need some court interaction to appoint the personal representative and guardian. So probate is the legal process to appoint them. So here's another example of probate. So she passes. He's the beneficiary of the life insurance, so no problem. Joint owner of the house, no problem. But we have this bank account just in her name. So that could be a problem. So there's a last will and testament. What do you think would happen if you walked into the bank with the will and says, I got the will, I'm the guy named to be in charge, and I'm the beneficiary. Can I just have the money? Do you think that'll work with the bank? No. So no, the bank's going to say, we need proof. So you're going to activate the will. The bank's looking for, it's called the PR letters, the personal representative letters. Sometimes these are called letters testamentary, but it shows that you have the authority for the estate. Now to get appointed as a personal representative, there's a lot of steps for probate in Arizona and California. So it's very time consuming and it can be frustrating and expensive. So usually it's best to avoid probate. All right, trust. What is a trust? So it's a legal document. The person that makes it is called the trustor. So I use this briefcase. It's like the boss. Trustee is the manager, and the person that benefits is the beneficiary. So usually a person makes a trust for themselves, they manage it, and then they're the beneficiary. The reason they do that is to designate who would manage the trust in the event they're unable to, in the event of their disability or death, and then where things are going to go when they pass away, and when and how they'll get there. So a lot of times, or the most common restriction is just an age restriction once the beneficiary reaches a certain age. All right, so how does a trust avoid probate? In this example here, you see his house is owned by the trust, his bank account's owned by the trust, this unlocked, meaning revocable. So as long as the boss is around, the trustor, they can make changes to the trust, so therefore it's unlocked or revocable. Now, after they pass, no more boss, so the trust is locked, irrevocable. Technically, it's revocable and irrevocable. If you want to be proper, we know that's the proper way. Yeah. So the successor trustee needs to get avoided. So the trust avoids probate. There still is some work to do to get this person appointed as the trustee. All right. The life insurance and the IRAs, they'll go to the beneficiaries listed. So whoever was listed on that contract as a beneficiary, those will go to them. All right, successor trustee gets appointed, so they need to sign some documents and prove that they accept that position. They need to get a tax ID number and some other things, and then they'll be able to collect all the accounts in the trust and distribute them to the beneficiaries. All right, in this case, they're both over 21, so they get their shares outright. All right, so now the sample scenario. So we got a few little scenarios. I used AI to build these scenarios. It was kind of fun. You guys watching live or on the replay, leave in the comments. Let me know if you know any of these people, if you've met any of these characters. I feel like we've seen some of these people. So we'll start with Gary, the independent Adams. So he's a retired high school shop teacher, known for fixing everything with duct tape and WD-40, builds elaborate birdhouses resembling famous landmarks, refuses to throw away old magazines, insists they might become valuable antiques someday. So 5 years ago, Gary, a stubborn do-it-yourselfer, read online about beneficiary deeds and drafted one to pass his mortgage-free $450,000 home to his son, Steve, a single dad raising 2 kids. All right, a lot of info, a lot of text. So he did a beneficiary deed for his house to give it to his one son. Figured it was a simple fix, no lawyer needed. Life hummed along until when Gary was 72, he suffered a stroke while sanding a Louvre birdhouse. I was going to change it. I don't know how to say it. Is it the Louvre? The Louvre? I know that's where the Mona Lisa is, right? But so he survived, but he needs round-the-clock care, costing $6,500 a month. Steve, his son, juggling a job and kids, tried to sell the house to cover the cost of his father's care. Gary, the dad, he did have a durable power of attorney, but the title company said no dice and would not accept the power of attorney. So issue. Beneficiary deed does not protect in the case of stroke or disability. So why won't the title company accept Steve powers of attorney? Who knows? All sorts of reasons, huh? Too old, too this, too that, didn't like the color of ink, didn't like the terms in it. It could be any number of reasons. But so the next question, is it common for institutions to reject powers of attorney? So what do you think? Lori's watching in the background. She's shaking her head. My probate paralegal sees it all the time. I think Tristan's seen this before too, as well. Helping people in those kind of difficult situations. So how could have Gary planned better? What would have been a better choice? So I don't do beneficiary deeds. I only do trust. So it would have been better if the house is in a trust. Then his son could take over in the event of his disability, and his son would have been able to sell the house or access the equity as the trustee. So one of the earliest examples I saw of this in my career, I remember there was a lady and her husband had Alzheimer's, and she was trying to refinance. And she had a power of attorney. It was only 6 months old, but for whatever reason, the banks didn't like it. So she wasn't able to do anything. And the bank said, we need a new power of attorney. They're like, her husband's incapacitated. They said, not our problem. We're not going to do it. You figure it out. So it's kind of, I blame the attorneys, right? There's just a lot of liability. So institutions don't like powers of attorney a lot of times. All right, here's our next friend. We have Donna, the Optimist Miller. So she's a yoga instructor and enthusiast who believes positive thinking can solve almost anything. Runs a podcast titled Zen Estates about peaceful family estate planning, ironically facing her own family estate crisis. Her podcast, Zen Estates, started as a passion project after her mom, Marjorie, bragged about a revocable trust to avoid probate hassles. So Marjorie, the mother, was a gardener set up the trust 10 years ago with a lawyer, listing Donna and her brother as beneficiaries. She'd say, "No fighting over my roses or my house, but last year, Marjorie, 78, passed after a sudden heart attack." Donna, grieving, discovered the $380,000 family home with the $40,000 mortgage was still in Marjorie's name, not the trust. Now, Donna, stuck in probate court, her podcast listeners emailing her for advice she can't follow herself, while her brother pushes to sell the house she wants to keep as a yoga retreat. So the issue here was the family home was not transferred into the trust, triggering a probate. So having a trust is good, but you got to have the trust funded. So I use the analogy of a bucket. The trust is like a bucket, and you got to fill the bucket. So unfortunately, this happens quite a bit too. This is an interesting question. Can Donna avoid probate with intent evidence? What do you think? We'll picture your head. Not in Arizona. Maybe in California is the answer. So in Arizona, no, but in California, maybe. So there's an option in California, but Arizona, no. So what steps resolve this if the house is not in trust? So probate, that's right. If it's not in trust, they're going to have to go through probate to collect it. So how to ensure trusts are funded? So sometimes this happens, I think, during a refinance. Someone creates a trust a long time ago, and sometimes as part of during a refinance, you sign a bunch of documents, and one of those might be moving the house out of the trust. So that's a common way where people don't realize that their house got moved out of the trust. The other thing I would say, too, is you want to review your plan at least every 3 to 5 years. So just to make sure that it is funded and everything's in there. So for those of you tuning in on the live, we're going to do questions and answers later. So if you have any questions, you can put them in the comments, and I'll get to them later after the last scenarios. All right, now we got Coupon Bob. Coupon Bob, retired accountant, known among friends as Coupon Bob, famous for finding outrageous deals. Crowning achievement was saving $187 on a $200 grocery haul in 2019. Still brags about it at bingo night. His house, a patchwork of Craigslist finds like a lumpy green couch and a wobbly oak table, reflects his thriftiness. 3 years ago, Bob's wife, Carol, nagged him to make a will. Too cheap for a lawyer, he downloaded a free template online, scribbling notes about his $120,000 savings, $300,000 IRA, and an $80,000 classic car collection, which was a Mustang and a Chevy Nova he restored himself. Carol died last year, and Bob's health declined. After Bob's passing last month, his kids, Lisa, a nurse, and Mike, a mechanic, found the will stuffed in a coupon binder. Is that like a band, Mike and the Mechanics, I thought of? Lisa saw IRA to Lisa, but a sticky note said Mike gets cars and half IRA. The bank and IRA company won't budge without clarity, and the siblings are now bickering over who gets what. So the issue is a DIY will with contradictory notes causes disputes over bank account, IRA, and car collection. So we see this a lot too, don't we? I mean, Lori back there. So there's just kind of a scenario today where I was looking at documents. So, all right, this isn't very good. So now what happens with this? And where they contradict themselves. So the ones I was looking at today, I think they were even done by an attorney, right? And they were horrible. So that's sometimes DIY can be bad, doing it yourself, and even just bad advice sometimes. So why will Bob's will spark legal battles? And that's pretty clear, right? Just because it looks like it's saying different things. Yeah. So how to handle the unclear IRA beneficiary? What? That's right, probate. So if it's unclear, if anything's weird, the IRA company is going to want to probate to sort it all out. So what should a Bob have done differently? Now, if you did it it's hard. Like people say, "Can I do it myself?" It's like, yeah, as long as you don't screw it up, right? So what he could have done is just left clear instructions. So just left clear instructions, or got help. All right, now we got Elaine, the forgetful Harris. I think she's our last one. She's a high-powered corporate executive known for excellent professional attention to detail, but notoriously forgetful personally. Enjoys competitive speed knitting and holds knitting marathons with friends. Apparently, that must be a thing, huh? She once forgot she owned a vacation cabin until the county called about property taxes. 15 years ago, she was married to Greg. She named him beneficiary on our $500,000 life insurance and $800,000 retirement accounts. They divorced a decade ago, and she remarried Tom, raising 2 kids, Mia and Jake. She meant to update the paperwork, but let's just say forgot. Last month, Elaine died in a car accident. Tom and the kids were stunned when Greg, now remarried and living across state lines, claimed the funds. Mia and Jake, college-bound, faced losing their inheritance to a man they barely remember. So who inherits the life insurance and retirement accounts if the ex-spouse is still named? So what do you think is going to happen? Is it going to go to that ex-husband? Not necessarily. Not in Arizona and California. So there is a rule. It's easy to remember. They treat your ex as predeceased. So once you get divorced, everything that your ex-spouse was listed on, it cancels that. So it's not necessarily going to go to the ex-husband unless there's a couple exceptions. So one is unless after the divorce. So after the divorce, if she put her ex-husband on it after the divorce, then that would count. And then there can also be some federal preemption. So if there's federal retirement accounts like ERISA, that's gonna be controlling. We saw this recently too. There was one I was all cocky and thought, oh no, they're divorced, but it was actually one of these federal retirement plans. So it ended up still going to the person listed in there. Okay, so summary. What did we learn today? Beneficiary deeds don't protect against incapacity. Trust must be funded. Leave clear instructions. So I'm not necessarily going to beat up the people doing it themselves. We have some resources, and I understand there's sometimes a place for that, but just leave clear instructions. You don't want to contradict yourselves and leave instructions in multiple places. And then update beneficiaries. You want to update everything to make sure it's current. All right, we have some free resources for you on our website, riluslaw.com. So you can go there. I got an AI bot there that can answer your questions, and we have some free resources as well. Our next event is going to be April 24th. We're going to do a trust and estate workshop. So you can attend same way, live here in person or online. The link, you can find that on our website, riluslaw.com/events. And we got a special offer for you guys. We're going to do a referral program. Now, I know a lot of you guys attending and watching this, you guys are the responsible ones. A lot of you already have your plans done, but maybe your friends or family needs to get theirs done. So we're going to entice both of you guys a little bit. So if you refer someone, we're going to give you guys a $100 Amazon card, and we're also going to give them 10% off of our estate planning prices. So this is for estate planning packages only. And you can also refer yourself technically too, I guess, and take that discount on your own and take that. We'll give you the Amazon card too if you mention this program. So thanks everyone for watching. Is there any questions? Anyone on the live here or anyone in person? Did you have any questions for a closeout?
If you haven't paid off your mortgage, can you do a trust?
If you've paid off your mortgage, can you?
Haven't paid off your mortgage.
Yes. So the question was, can you do a trust if you have not paid off your mortgage? Yes, you can. So you still own the deed to the house. The bank has a security interest. They have a note. So even if it's in a trust, the bank can still foreclose if you don't pay them, but you can transfer your house into the trust. And that is the case. Most people don't. Most people have mortgages on their house, but it's still important to protect that equity in your house by putting it in trust. Thank you. Good question. Anything else? Any other questions? Yes, Tristan.
How difficult is it to modify a trust? We're talking about setting up, but then, like, my brother passed a year and a half ago. I need to come and see you. What's the process to change a trust once it's in place?
Yeah, so the first time setting up a trust, it's a little bit more work because you got to do the funding, right? You got to fill it up. So theoretically, it should be funded, but I still like to review that. And then the process is, so technically, some attorneys or planners will do just an amendment where they go in and change this one place.
Yeah.
I don't like that because it gets confusing. It's really easy to make a mistake with the amendments, and it gets hard to read.
Especially with multiple amendments.
Yeah.
The way you lose that intent.
Yeah. So I do a restatement. So it's your trust keeps the same name and original date, but we can rewrite the terms to change anything that we need to update. So yeah, see Paige, we'll get you scheduled to do that. So it's we go through kind of the same process, but it's just it's not the same.
Review everything along the way instead of just one little bit. We might miss a divorce or whatever.
Right. Yeah, we want to look at everything, make sure.
No longer funding.
Yes. Yeah. So yeah, thank you. All right, thanks guys for coming, and we'll see you next time next month, live or in person.